be seated. We're here for oral argument on Roundtree et al. Versus Page, hour number CV24-0144. A couple of things before we get started. First, Justice Cruz has recused herself in this matter, so sitting with us today in her place is former Chief Justice Rebecca Birch, and we're very pleased to have her here. Thank you very much, Justice Birch, for filling in. Both sides, you all know, you have 20 minutes. You may keep whatever time you wish for rebuttal, but you have to keep your time yourself, so watch the clock. Please proceed.
Good morning. May it please the court. Jim Barton of Barton Mendez Soto here on behalf of Deborah Roundtree, Stephen Kidman, and the Page Action Committee. Today I want to address two things. First, the courts below applied the wrong rule in evaluating this initiative. And then secondly, they applied the rule wrongly. So the result is we now have local initiatives and local referenda at jeopardy as a result of these decisions. And so I hope the court would take the opportunity to set the record straight on both counts. We begin and end with the words of the Constitution. Article 4, Part 1, Section 2 starts off by explaining that the powers of the initiative and referendum are reserved for the qualified electors. The powers, plural. Initiative and referenda are different, and referendum are two different powers. This is also clear. If you read down a little further, you see that it takes 15% of qualified electors to propose a measure. It takes 10% to refer legislation that has been enacted.
Mr. Barton, may I ask, I'm just trying to get a sense of, try to divide and draw these lines here. The project, the streetscape project itself, that was approved by the City Council, correct?
Yes.
Yeah. I mean, that's not an ordinance, it's simply an approval of a project, if I get that right. Could that have been referred to the voters?
Justice Timmer, at some point, something about that project probably could have been referred to the voters. In other words, at some point, as you saw in the Court of Appeals decision in Workers for Responsible Development, when you do a remodeling, when you do a rezoning, and you sort of do a big project like this, when you set the policy, when you establish what you're going to do and how you're going to do it, that could be referred. So I think at some point along the way, this cityscape or whatever the project is could have been referred. The electors in City of Page chose not to do that. They did not refer that project. Instead, they passed a general law that is permanent and a law that will preserve that strip of road in general against all future projects. Even, for example, if they were to take over the City Council, should this measure pass, it would apply to them.
Well, and and that raises a few points about the constitutionality of that proposed initiative if it passes. I mean, it certainly instantly raises like, oh, is that a special law? And does that interfere with contracts? I think as Amiki brought up. But is that type of thing pertinent in deciding whether initiatives should be referred, or have we already said that that's the type of thing, I know we've said it with state legislation, that we look at if and after it passes?
We look at after it passes, if it passes, is when you evaluate the constitutionality, when you evaluate the substance. So I would say it's not always perfectly clear to me which is substance and which is form, but I mean certainly if it violates the contract of some sort, that would be substance. If it was unconstitutional for some other section, it violates separation of powers or something, that would be unconstitutional. And I don't think you would evaluate that at this point. Special legislation also, I think, would not be evaluated at the opening. That would be something that if it passes, and only if it passes, would you evaluate it ahead of time. So in this case, we have a measure that was initiated. They didn't refer to the project. They initiated a measure. And when we look at the words in the Constitution, when the legislature, or in this case the framers, use two different words, we assume they have two different meanings. And in this case, we have one sentence at the end of the clause that says initiatives need 15% in order to, the electors may propose measures. So it says propose measures. In that same sentence, it says legislation enacted. So legislation enacted cannot be the same thing as measures proposed. It's in the same sentence. As a matter of fact, in Fan v. State, this court looked at a very similar set of issues in determining that the tax enactment clause did not apply to Proposition 208. In that case, the court noted that the Constitution uses the term measures when it's describing initiatives, but in Section 22, it uses the word act for the tax enactment clause.
What do we do then? I mean, haven't we addressed this already in League of Arizona Cities and Towns? We said we'll review to determine whether an initiative in fact constitutes legislation.
Thank you, Justice Timmer. We did say that in League of City, the court did say that in League of City Towns, whether it constitutes legislation. That to me is different than whether it's legislative or ministerial. Whether it constitutes legislation, and that was, first off, I don't know if that was an issue in League of Cities, whether it was ministerial or legislative. And in any case, that was referencing Saggio as well. So if we look at what Saggio did, Saggio, I wish Saggio had said it was evaluating whether the thing was a measure. Unfortunately, that's not what the court said in Saggio. The court said we're evaluating whether it's legislation. But whether it's legislation is a question of, does it do a thing? If you look at what Saggio said, Saggio said that it invalidated the ordinance because it doesn't indicate whether it's an ordinance enacting new legislation or amending an existing legislation or repealing an existing ordinance. It basically said this poll that you put out in Saggio of whether we should, what we want somebody to do, that's not, they said it's not legislation. I wish they had said it's not measures. But I think you can keep Saggio and say, well, there is something left here, which is that if you're going to initiate something, it has to be a thing. It has to be actual legislation. It can't be a poll.
Well, what about the language inside the first sentence of subsection 8 that deals with the local city, town, or county matters? It begins, and I think your opposing counsel pointed this out in the briefs, it says, powers of the initiative and the referendum are hereby further reserved to the qualified electors of every city, town, and county as to all matters on which such incorporated cities, towns, or counties are or shall be empowered by general laws to legislate. So doesn't that require some sort of determination of whether this is a legislative or administrative?
Justice King, I don't think it requires that. I think it requires to make sure this is a matter. It covers a topic that is within the jurisdiction and auspices of the particular city or town, which is unquestionable here. I mean, in fact, there's in the Court of Appeals opinion, it cites to the fact that it's not only within their power, it's within the exclusive power of the city council to have to legislate over streets, alleys, avenues, walkways in town. So certainly the matter of the initiative is within the ability of the city to legislate. It is in that. And I think if we want to look for a counterexample of where something did not satisfy the matter, the court can look to, again, it's a Court of Appeals case, Cota Robles v. Tucson, and that was a case where the citizens of Tucson put something in place. They passed something called the Neighborhood Protection Act. They added it to their charter, and they said any kind of thing that happens with highways, you need to refer that to the voters. Well, the problem is that once a parkway was established as a state route, now that highway got pulled out of the jurisdiction of the city of Tucson, so it was no longer a matter on which Tucson could legislate. And so, unfortunately, the Court of Appeals decision actually then did not decide, because there's a question, if it's not the matter, is that form or is that substance? Well, what the court did is it just said, well, the Neighborhood Protection Act is unconstitutional, so you lost the whole underpinning of your ability to refer it. But that's the kind of thing that we're evaluating when we talk about matters that are under essentially the jurisdiction of the city or town. In fact, if you look at Winterstrom, the referendum case that we've talked about so much, you can see that the Mesa electorate kicked things off. The Mesa electorate approved the city's request for authorizing a bond. So in Winterstrom, they tried to refer an act by the city council that was implementing an act by the citizens of Mesa. And they couldn't refer this one. They couldn't refer the act by the city council because it was implementing something that was already in place. But the thing that was already in place was also voted on by the citizens. So there's just no prohibition to the citizens enacting measures that establish policy. There's no problem with citizens enacting measures that cover roads. And that's what happened here.
But even Winterstrom, I mean, Winterstrom's talking about, is it legislative or administrative? I mean, that's the context. They didn't use the terminology measure, that this is okay because it's a measure. It's all focused on legislative, administrative. So maybe you could turn to that. Why is this initiative legislative rather than an administrative act?
Of course, and the court in Winterstrom was evaluating a referendum, but the thing that it based it on was an initiative that had been enacted by the voters. So I do want to emphasize that we don't have any case, except for this case on the Court of Appeals, where Winterstrom factors were applied to an initiative. We have no cases of that. And in fact, even if you look at Saggio, which did limit an initiative, it wasn't doing this ministerial versus admin evaluation. It was doing this is it a thing evaluation. And I think if you look at the initiative, the text of the initiative, it's clearly, I mean, this is an act. This is a measure that the citizens have referred. It has purpose and definitions. It talks about what its point is, which is to preserve a certain stretch of land. So if you apply the rule under Saggio, it certainly passes.
You know, you brought up a good, an interesting point that I wanted to follow up on, because Winterstrom was a referendum. So you're looking at, should we refer this ordinance to the people? So it makes sense there, to me at least, that you would determine, is it legislative or is it administrative? But cities do more than just legislate and administrate. They also can be an executive function, and they have quasi-judicial functions, and we have said that before. So what do we do with that? I mean, can that be the subject of an initiative, something that's really an executive function or quasi-judicial function?
Well, yes, it could be the subject of initiative. It may not be enforceable down the road. But again, so we have this language. It says that proposed measures can be proposed, legislative acts can be referred. So those are different. And if you look, shortly after the Constitution was enacted in 1914, we have State v. Osborne, and they considered this very exact question: can they create a new Miami County? And there was objection. Well, it's a special law. Well, this is more ministerial. And the court said explicitly, whether the voters in taking this step are acting ministerially or in their legislative capacity is immaterial. So this is 1914. This case has not been overruled. And this case, in 1914, this court ruled we don't care whether it's ministerial or administrative when we're talking about initiatives. Now, it could be unenforceable. Like, you could pass a special law, and if you did something that was, say, executive in nature, it might very well be a special law. Well, then that would be reviewed if and when it was approved by the voters. I do want to apply the Winterstrom factors to the initiative, though.
Yeah, Mr. Barton, and maybe this is taking you right where you want to go, but assuming for the moment that we're compelled by the precise language which talks about the city council acting on areas in which they're entitled to legislate, if we were to read legislation or power to legislate broadly, explain to us how this particular initiative falls within the city's power to legislate. Could they legislate on this issue?
They not only could they legislate on it, it's the exclusive control of the city council over streets, alleys, avenues, and sidewalks. So not only could they, in fact, they're the only ones who could initiate it, but of course, if the city council can do it, then the citizens can do it. And so if we want to now apply the...
Before doing that, one conceptual point I wanted to ask you about, assuming that we apply Winterstrom, the factors here, it seems to me that one of the differences between an initiative and a referendum is that the analysis, our analysis with regard to a referendum, would be on whether the predicate action, that is, what the city did that the voters want to refer, is legislative. With regard to an initiative, though, it strikes me that what the city has done up until now is utterly irrelevant. That we look precisely and solely at whether what the citizens are proposing is legislative. Is that an appropriate line of demarcation?
Yes, Your Honor, because when you're looking at just the citizen, now you're looking at doing what sort of Sajio did. Is it legislation? Is it a thing? Is it a measure? And I think that's necessary and appropriate because you can't just initiate polls. But in the Winterstrom doesn't work because of just what you said, Your Honor, because one of the factors, and what we've said is, what this court has said is the most important factor, maybe the Court of Appeals, is does it further the previously established plan? And in this case, I will admit to being surprised that the Court of Appeals held that this somehow enacted whatever it's called, cityscape, whatever the plan was called. This measure preserves this strip of road. It absolutely announces a new policy. The old policy was we're going to change it and develop it. This is a brand new policy. We're going to preserve it. And so had this been passed by the City Council, so instead of being an initiative, the City Council had voted, the new Chapter 74 that we want to add to the city code and page. Had the City Council done this, it absolutely would be subject to referral. First and foremost, because this is the new policy. We're going to preserve it. We're not going to develop it. This tells you how you're going to do it. It lays out the purpose. It gives you definitions. It says what time. All of those things make it a thing, so they make it a measure, but they also sort of show that if a City Council had done this, it would be referable. It's also permanent and it's also general because there's no expiration date on this. This isn't some kind of conditional use permit that's going to expire at some time. This is forever until somebody changes the law. And it's also general in that it applies to everything. In other words, any kind of project you want to do on this road.
One other, and I realize I'm eating into your time here, but Winterstrom did not articulate this three-part test in isolation. It also applied the Quillen analysis, which seems more focused, at least to me, on whether something is legislative or ministerial or not. Do you think that this also satisfies that standard?
If this was passed by the legislature, by the City Council, yes, it would be legislative under McQuillan because it has its own policy, because it's permanent, because it's general. I will note that, and I appreciate the reference to McQuillan. McQuillan uses referendum and initiative interchangeable. I think in the vernacular that's true. Obviously that's not true. Our case law is chock full of distinguishing between initiative and referendum. So, if I may, I'd like to reserve the rest of my time.
Thank you.
All right.
Okay, is it Mr. Palladini?
Good morning. May it please the court, John Palladini with Pierce Coleman. We represent the city of Page appellees in this case. I'd like to start off with, and I think Justice King pointed to the language about the power of initiative, and this is in the Constitution, and the question of the court is, does the initiative comply with Article 4, Part 1, Section 8 of the Constitution? And it simply says that the power of initiative is reserved to the electors of the city as to all city matters on which the city is empowered by law to legislate. Legislation, as Chief Justice Timmer pointed out, the city council is not like the state legislature. State legislature legislates. It's all they're supposed to do. City councils legislate, they act administratively, they act with executive powers, and they act in sometimes quasi-judicial manner. If you take the appellant's position that a measure is anything that the council can do, that creates chaos in the sense of, can the public initiate who the fire chief is, if that's the city manager's function?
Counsel,
can the public initiate?
Counsel, let me ask you
Yes.
a question that will sort of narrow it down. Accepting administrative, executive, and quasi-judicial acts by the city council and staying focused on legislative, can the city limit the people's ability to initiate laws if they delegate a legislative function to an administrative official?
No, because the council.
So why do we care if the administration of the city streets were delegated to the city engineer?
Because this is a direct, this is a public initiating directly an administrative function.
Well, but we just, that's why I asked the question I asked.
Maybe I misheard.
The city has the authority, as delegated by the legislature, to legislate on roads. Just because the city delegated the administration of that function to the city engineer, how can that immunize streets from the initiative power?
With all due respect, Justice Montgomery, the legislature didn't delegate the power to legislate. It gave the ARS 9204 gives the council the exclusive control over it. It doesn't necessarily mean that it's a legislative function to control those city streets. It's an administrative function, and then the city council.
So how, you've lost me. So when the city wants to, say, create a street, or change a street name, or do anything, wouldn't they enact an ordinance?
Not necessarily.
But they would
But they
delegate
could.
that to the city engineer?
They could delegate that to the city
Okay, so
engineer.
that gets back to my question. This
Okay.
is really where I'm trying
Okay.
to focus you, because I want to understand the distinction here. The city has the authority to do those things by a statute. How do they avoid, then, the people being able to initiate on that same topic just because they've delegated it to the city engineer?
Well, it's not just because. It's because the legislature gives the city council the exclusive control. Then if 9204 is, and disagree with Mr. Barton, it doesn't give the public the co-equal right to control streets. If that were a legislative act, then that 9204 would be unconstitutional, because the legislature can't give exclusive, meaning only the city council can address it, on matters that relate to streets. So when the city council is dealing with streets, it's an administrative function as a result of ARS 9204, which gives council exclusive control. And if you think, and then, so the council's not delegating legislative authority to the city engineer. It can't. The city engineer can't act legislatively. Only the city engineer can only act administratively or as an executive branch, if you will, of the city staff.
Well, could the city here have passed an ordinance which is identical to the proposed initiative?
I don't believe so, because well, first of all, the initiative, and this is one of those issues that would be dealt with after the fact. This initiative says nobody can change this. If this rule passes, nobody can change it other than by initiative, and so it binds future. It binds future legislative bodies. And as we all know from case law, the public is a co-equal legislative branch of government. It's not a co-equal administrative arm or an executive arm. So when we're talking about initiatives, the public has to initiate law or initiate legislation.
Let me wind that back a little bit. Could they, forgetting if the initiative, if it passed, or the ordinance, if it passed, was actually constitutional, because I think that those are different things. We don't prejudge what a city does proposing an ordinance, can't swoop in and say, oh, you can't pass that because it's unconstitutional. We'll wait until somebody challenges it if it passes. So kind of putting all that aside, the pre-passing, I'm just wondering, could the city, if they wanted to, decide that the street in that same mile or so must be, can't ever be widened? Could they pass something? Do they have the authority to do that?
They have the authority, but it's not legislative authority. It would be an administrative type authority. Because
But I want to make a distinction here, and maybe I didn't ask my question in the right way to try to highlight this. But when the city does that, they may exercise that authority through an administrative official, but the fact that they have the authority in the first place to do anything with it, they could do it all on their own without delegating anything, which would make it legislative. Where am I wrong?
Well, I disagree with that, Your Honor, because the council doesn't act exclusively as a legislative body. Council makes a bunch of administrative decisions. Approving a contract for road widening is an administrative decision. Refusing to approve the contract for road widening is also an administrative decision.
But we're not talking about that here. What we're talking about here is the width of the road and the number of lanes. I read ARS 9-240B3A as giving the city council exclusive control over that. That's a delegated power. That's a power that under the Constitution, then, the city has, the general authority to do. How they do it, they could do it administratively, they could do it quasi-judicially, but they have the legislative authority to do that. Do you see that distinction, or?
I think there
maybe
is.
That's the crux of this. You don't see the distinction.
I think there is a distinction because first of all, when the city councils don't enact legislation to control future city councils. In other words, if they didn't want the road to be widened, they would simply not widen it. It would be sort of by default. And remember, and Mr. Barton conceded this point, this city council adopted a strategic policy or strategic plan to widen or to narrow the roads, to build, to streetscape, to narrow the street. That was the referable act in this. So when Mr. Barton says later on, if that's the referral act, the execution of that legislative referral act, the execution of that is administrative. So when the council's going forward, entering into, and in this case, the facts show that council's entering into contracts block by block to do this streetscape project.
So what if after a 6-year study, the town council decided that our plan for Lake Powell Boulevard is to keep it as wide as it is now, but we're going to redo the lighting and the safety signs and the walkways around it? Could they have put that into an ordinance and passed it? And if so, would that have been referable?
If I understand the question, Your Honor, the council's strategic policy, whatever it was the legislative act. So if it didn't involve, let's say, medians and streetscaping, but it involved some policy level decision about dark sky lighting, let's say, the execution of which is, well, what lights do we buy? That's the administrative act. So it's a case by case, and this is where Winterstrom makes it very difficult in these instances. It's a case by case analysis, and in this particular case, without sort of going into, with all due respect, without going into sort of hypotheticals, in this particular case, the strategic plan was the legislative or policy act. The execution of these contracts then, which the city entered into the facts show, entered into one to do this work on one block, and it was going to be block by block of basically 1/3 of Lake Powell Boulevard, which also is problematic in this case because, the prohibition of ever widening this, ever narrowing the street or changing the lanes is really not of general application to the city as a whole. If the city council said all arterial streets in Lake Powell shall be X, whatever width, or shall have 2 lanes, or all shall have medians, then that's probably as close to legislation on the streets, and the public could probably, and again, I don't want to get too far afield, but the public could probably initiate something like that. But
well,
again,
I posed a conceptual question to Mr. Barton. Why does what this, and this actually gets to a question Justice Montgomery asked as well, why does what the City Council has done matter in terms of us analyzing whether an initiative is legislative or not?
because the test that Winterstrom gives us is what is legislation? Legislation is adopting a policy. Administration is executing that policy. And in this case, the initiative attempts to, I guess, prevent the policy from occurring, but in a way that's so limited that if you read the language of the initiative, you can't even contemplate. You know, staff can't contemplate. So it drives down into layers that the city manager can go to the city engineer and say, hey, I don't want you to waste any more time thinking about this part of Lake Powell Boulevard. The public acting in that manner to tell the city engineer, don't think about this anymore, is infringing on the city manager's authority, which is clearly an executive function.
How dare the people tell administrative staff how to run their city?
Well, with all due respect, Your Honor, the public can tell can adopt legislative acts, But in this case, the way that's the other problem is when we're dealing with this specific initiative, the way it's written is very problematic. It's not as if the public initiates something, like I said before, that says you shall do this with all arterial streets, or all collector streets shall have no on-street parking, or something like that. And then the execution of those legislative or policy level decisions are then delegated down to the manager and the city engineer and those things. But imagine the chaos if the public could initiate contracts or initiate, that the city engineer shall never contemplate narrowing the street down.
Well,
Why can't we construe the initiative as the wholesale rejection of the streetscape project?
Well, the way it's written. The way it's written is problematic. Because it doesn't repeal that strategic plan. And again, if that was, and this is where I think it's also problematic, is if the referendum, and Mr. Barton concedes this, the referendum would have been the proper venue or proper mechanism for overturning that strategic street plan. They had 30 days to collect the signatures, and the timing doesn't necessarily have to be an ordinance. It's when the minutes are available or when the resolution's available, whatever the approved document is, that would be the referable document. That was legislative.
The trial court noted that these are not coextensive, that what is being proposed in the initiative here is not coextensive with streetscape. Is that an erroneous factual finding? Does streetscape consist entirely of narrowing this roadway?
The trial court actually made 3 findings of fact that clearly indicate that this is an administrative act.
No, I know the court did that. It actually concluded that the streetscape project was administrative, which then would, from your argument, I would think would take it out of the realm of referendum. So I think even you would agree, or it sounds like you would agree that the trial court erred on that. But in its decision on page 5, note 2, it notes that this initiative, the impact goes beyond the streetscape project. So it is not, that is a purely factual finding.
I think the trial court found that the budgeting and appropriation and the strategic plan were both policy decisions by the council. Now, the budget's not a referable item, even though it's policy, but the strategic plan, which is approved, the facts show every year it gets reviewed and approved. That's a policy level decision that would have been referable. The subsequent execution of that legislative act is, by Wennerstrom test, is an administrative act. And so had the public, and I don't, it's complicated because, and I don't know if the cases have dealt with this, if the public fails to repeal or refer a legislative act because it missed the timing, could it then later on go and initiate a repeal? Most likely, yes, because it is a legislative act. Here, this initiative doesn't do that. Had the public initiated a repeal of that strategic plan, arguably, that would be a legislative act. Here, again, the language of the initiative is what's problematic with it, because it delves down into things like you can't spend any time thinking about it.
There's a case from a great year, 1957, that Williams versus Perrick, that upheld an initiative on these grounds, enacting a comprehensive scheme of employee classifications, hours, salaries, et cetera, holding that was legislative. Is that bad Is that bad law? These are quintessentially, ordinarily, ministerial, administrative decisions on the part of the city, what to pay a particular employee.
No, Your Honor, before my time, just for the record,
Oh,
but.
sorry. Oh.
No, I'm saying that 1957.
Okay.
I think that's the key, though. It's a comprehensive personnel policy. And councils, budget, again, policy making, budget for raises, budget for cost of living increases. So all of those decisions, I think, are policy level or legislative decisions. I think that the council gets into deciding who gets what raise, this employee, then I think they're outside of the legislative realm and they're delving into perhaps executive type decision. In fact, when the council hires a city manager, the council negotiates a contract with the city manager, and the city manager negotiates a salary. That's an executive function. If Mr. Barnes' argument is correct, the public would be able to initiate a contract with the manager, and it's just carved right into the separation, the sort of this internal separation of powers that a council has to deal with, unlike the state government where you have clear lines. The council,
But the voters could, I assume, enact an ordinance that says the city engineer or the city manager may never be paid above a certain amount. That would be legislative, that would be a policy.
Perhaps with regard to the city manager, if it's not specific, I'm not sure about the city engineer.
We are splitting hairs here.
Well, are ordinances passed by the city council, are they always legislative?
No, because some, for instance, charter cities require that real estate agreements or real estate contracts be done by ordinance. And I would argue that real estate purchases or sales, just because the form is ordinance, doesn't necessarily make it legislative. In the same way that if something's approved by resolution, doesn't necessarily make it administrative. So I think that's form versus substance. I think you still have to look at the Wennerstrom test on the substance of the issue. And on this particular initiative, the way it's written in the facts, these are clearly administrative functions of the city staff. And if I could reserve 40 seconds, unless there's more questions, on my time.
What are you reserving it for?
I have no idea, Your Honor.
Use it now. Use it now.
I'll use it now then. Let's proceed. If you have any more questions, happy to answer. But again, this...
Well, I'll ask a quick question. This is really quick in your 21 seconds. And the reason I asked about the ordinance is because the city of Page delegates authority to the police chief to regulate traffic, but then it also specifically has an ordinance saying, but you can't park, load, or unload passengers on an entry road to Horseshoe Bend, also known as Page Parkway, or loading or unloading passengers along Highway 89 within 1,500 feet of a particular intersection. I mean, that's an ordinance. That seems, is that administrative ordinance in your view?
You're right. Under that ARS 9240, that's if I can go over my time.
Please.
It appears that it could be legislative, but again, you're just like Title 13 crimes are legislative, or ARS Title 28 speed limits are legislative. They prohibit the public from doing something. This is completely different. This initiative is completely different. It's trying to restrict this council and future councils from ever, or staff, from ever thinking about doing something.
Well, and one last question, even though I'll take my prerogative as the Chief Justice. Do you have any authority saying that you can challenge, before an initiative makes it on the ballot, the ability to restrict future councils?
No. The League of Cities case provides two thresholds on procedural challenges. One is the form of the initiative is in error, or whether it's administrative versus legislative. All of the other, those are all post, if it passes, then you can challenge sort of the underlying constitutional issues.
Great. Thank you very much.
Thank you.
Hey, Mr. Barton.
I want to first point out that one of the reasons why it's important to treat initiatives and referenda different is because they function differently. So a referendum stops in its tracks a thing from taking effect, whereas an initiative doesn't do anything until it's passed, and then there could be a constitutional review, and there could be a preliminary injunction. So as far as the idea that maybe we would pass terrible initiatives and then they would have terrible consequences, the good news is those terrible consequences get reviewed, and it doesn't have the impact of stopping things in its track. And that's yet another reason, in addition to the law and the case precedent, on why initiatives and referenda should be treated differently. I also want, but focusing again on what this act does, for the same reason the strategic plan was appropriately passed by the city council, the citizens could pass the initiative in this case, which is a different plan, if you will. For the same reason that strategic plan was subject to referral, had instead the legislature passed this initiative, it would be subject to referral. So I think if you want to do Winistrom, which I kind of hope you don't, but if you want to do Winistrom on the initiative, for the same reasons the strategic plan would be referable, the initiative would be subject to referral. I agree, by the way, we could not, the block-by-block contracts, no, that's not subject to referral. But we could pass an initiative that said you're not able to enter into contracts like this. Maybe that would be wrong. Maybe that would be unconstitutional to do it. Maybe it would be a special law. All that will be reviewed after the fact. And then just one last point I want to make sure, as far as whether this is general, this street, I think if you look at the amicus of the former officials, this isn't just some side street. This is the big street in the city of Page. And so to the extent that 12.5 acres and workers for responsible development was sufficiently general to check that box, this is general, it's big, this is an appropriate thing. Had it been passed by the city council, it certainly would be subject to referral.
Quickly, what's your response to Mr. Palladini's assertion that the flaw in this initiative, that it's not a counter to the strategic plan, but it's too granular in detail, it's too specific and limited to roadway projects and funding related to roadways? What's your response to that?
That's just not the test of determining whether something, again, if we're going to do this legislative versus ministerial, you can pass legislation that is very granular, that gives you lots of details, that really impacts the way officials and administrators do their job. And there's tons of examples of that, not least of which is this strategic plan, which told the engineer how to do his job. So I don't think it's a problem that it's granular. It could be a problem if we were talking about contracts. You could have a problem if it's a special law, if you give a particular guy a particular salary. But again, that's after the fact. Once we get it passed, then it's time for that lawsuit. Thank you, Your Honors.
Thank you. Okay, thank all counsel for your briefing and your argument today. It was very helpful, very interesting. We will take the matter under advisement and issue a ruling in due course. We will stay on the bench to give the next set of litigants an opportunity to come forward.